Section 255, running down through to Section 269 of the 1999 Constitution as amended, states the scope and composition of the High Court of the Federal Capital Territory. Part of these sections also talk about other courts in the FCT, like the Sharia and the customary courts of appeal. At the head of all these courts, that is, the judiciary of the FCT, is Justice Ishaq Bello. This edition of the scale takes a look at the FCT Judiciary through the eyes of the Chief Judge himself, Justice Ishaq Bello. Welcome to the program. I am Femi Okeowo. Apart from being the Chief Judge of the High Court of the Federal Capital Territory, Justice Ishaq Bello is also the chairman of the Monitoring Committee of the Administration of Criminal Justice Act, that is, after participating in midwifing that act. Like the name indicates, the committee monitors how effective the ACJ Act is performing. These are the areas we are x-raying with the Chief Judge of the FCT in this edition of the scale.
This is a court for the Federal Capital. So if there's any ground for experimentation of some acts that are relevant to the jurisdiction of this court, definitely it is the avenue.
How then do you fare when a new law comes out and you have the burden of interpreting it first to Nigerians? How have this court fared in that area?
Very well, because primarily you are a lawyer, you have gone through the process of learning of the very principles of interpreting the law. So whichever law comes at any given time, you are already armed and combat ready to apply the knowledge towards the interpretation of that act of the National Assembly. So it's not a problem at all.
Okay.
Yeah.
Let's take the Administration of Criminal Justice Act. That is an act where, of recent, you have been very involved in re-evaluating it. But then, talking about the Administration of Criminal Justice Act, you have also been involved in its conception. Give us your assessment of the Administration of Criminal Justice Act.
It's a wonderful act. Very, very wonderful. And the potency of that act to address some of the inadequacies of previous legislation is superlative, because the spirit of that law is to address snail speed problem in the administration of justice. And not only that, the practice of making victim of crime merely a nominal complainant, and that it is the state that is aggrieved, is now a thing will normally go to lick their wounds with no specific attention in terms of provisions, legal provisions to cater for them. But today, with the restorative system of law as provided in the Criminal Justice Act, the ACJA, we have radically departed from that anachronism, and that today, victims of crime, apart from subjecting the victim to trial and upon conviction punished, the victim of the crime too has some solace through certain compensation, where, as provided specifically under the Act, he enjoys.
Have we seen that done practically in terms of pronouncement of judges?
Surely. Surely. As I said, as you know, the Act has just come into being, but nothing stops any judge from directing. We have also community service, non-custodial sentences in order to go far away from the usual practice of detention with the attendant problems, which as a lawyer you know as much as you do. But then coming back to whether it is practically done, of course, a number of judges made such direction in their rulings and judgments towards catering for victims of crime.
Now that you have mentioned this topic, non-custodial sentencing, another very great provision of the Administration of Criminal Justice Act. But then there are other institutions that should help if that provision of the Administration of Criminal Justice Act is to work, non-custodial sentencing.
Surely. That's like the probation officers.
Yes.
They are indispensable to dream of non-custodial sentences in terms of engaging them in community services. You need some specialized persons to superintend over their activities while engaged in such community services. We are already far in the process of arranging to have such personnel on ground towards actualizing the dream of community service. I believe by the time we are through with our budgetary proposals, adequate provisions would have been in place towards actualizing that dream.
Talking about
experienced retired prison officers who have plotted certain outfits for that purpose. We have even some foundations who had made proposals to us. Don't forget, I chair the monitoring committee for the implementation of the ACJ Act, and therefore we have received some proposals from various number of organizations hoping to provide such services of probation officers. So we'll look at that, and armed with the funds, we will look at that and decide amongst them those that can serve most effectively the purpose.
Talking about funds, have you been, has your court been providing witness expenses?
The Act came into being much after the budget for the year had been implemented more than halfway, and no provisions were made for state witnesses' funds. But this year, we have made such provisions, and I assure you we'll start paying state witnesses transfer fares to and fro.
How are there standards of assessing?
Oh, yeah, well, in those days when we were young magistrates, the registrar of the court, where witnesses are going to give evidence, is already having by his side the mileage book comprehensively laid down across. He only needs to look at the distance and compute the relevant amount and envelope. As soon as the witness is out of court, he's giving the money. We had some practical problems some years back where the fund for such witnesses were residing with the Ministry of Justice, which we considered anomalous. And now this act has brought it back to reside with the courts, which makes it easier, because it doesn't make sense somebody coming to give evidence in the court, and by the time he leaves, he has to start looking where the Minister of Justice is. Yes. That itself entails some financial expenditure. Moving from one place to another, you get paid where you went to testify.
And there won't be shortage of funds as to have some witnesses paid and some witnesses not paid?
We don't envisage that. Yeah.
Now let's look at one area you have allowed the public to know, that you are preparing a practice direction for the FCT High Court. Give us a picture of what that should look like.
Well, this practice direction that I spoke about recently is just one in the series. There's a practice direction which already I had signed and is being utilized in terms of enforcement of judgments, which is another area that has been presenting difficulties, real problems that seem to discredit the justice system in terms of delays. We realize that after judgment, some lawyers, without the intention of prosecuting appeals, they will just go and file, and they will never show up again. And any time there is move to enforce the judgment, they will run and say, we have filed an appeal. Now, I have handed down the practice direction. And part of it is to the effect that unless there is any express order, either from the judge that had taken the decision or the judgment, or from the Court of Appeal, we will no longer stop executing any judgment on mere statement that we have filed appeal. And it is our hope that the spirit behind that will be appreciated by all stakeholders, because the idea is to insulate the integrity of the justice system from being abused through inappropriate use of court processes. Because the dream of every person that succeeded in litigation is to get the fruits of his success at litigation. Now, if anybody is to employ the court processes for the purpose of preventing execution of judgment and therefore blocking that individual who succeeded from reaping the benefits of the judgment, I think it should not be entertained. You know, people don't see the lawyer that comes to stay the execution. They only see the court and the judge. And then, by and large, they tend to feel the system is incapable of giving them the solace they need. And people go about with heavy hearts, burden of worries in their hearts, and they start self-help, engaging in self-help, which we don't want to persist in our society. So day in, day out, you must bring certain approaches that will insulate the system. The next practice direction is to do with the criminal trial. Constitutionally, I have the power as Chief Judge to hand down practice direction. That is why I was able to do that, covering the civil proceedings. Now, within the realm of the criminal trial, we have perceived quite a number of anomalies, and we are going to address that through the practice direction covering criminal trial. And one of them is, I hope by the time it comes on board, the power that will enable me to set up panels of judges that remembering or recalling those good days of assizes, where they will handle the backlog of cases within specific we will pave the fast-track lane for incoming cases, meaning we have succeeded in eliminating delays drastically. Yeah.
This court has widened up so much over the years, and yet we still find that the judges are overloaded with matters before them. How do you intend, what's the strength of this court, and how do you intend to ensure that judges are not overloaded?
No, judges are really overloaded right now, as you observed. And we're only 36 now. The workload is really so much on the judges. Whenever I sit down to assign cases to these judges, I find myself pained, because it is an assignment that I must undertake knowing how much work is on their hands. I'm grateful to the powers of the day, the government of the day, including the National Assembly, that graciously approved appointment of more judges for this court. And if we are to go full length, we will have about 75 judges for the FCT. That will certainly reduce the workload.
How soon will that be?
Well, already we have set in motion. We wanted to get 20 this year, but the anticipated budgetary allocations are not likely to accommodate 20. So probably next year we will go beyond the 10 that we intend to initiate the process of appointing this year.
And one of the ways you have tried to hasten matters, and of course Sure. How is that working out?
Well, in my speech during the legal year, we expressed lamentations that although cases had gone to the multi-door court, it is by no means an indication of maximum utilization of the multi-door court. We are still battling with lawyers not wanting to go through the ADR mechanism, even when the then Chief Justice had made a declaration that cases resolved amicably through the assistance of lawyers, through the ADR, will count as part of the requirement for attaining the rank of senior advocate. I think that was deliberately designed in order to sensitize the bar and to make them submit meaningfully to the ADR mechanism, which would have gone far long way towards depleting the dockets of the court. But we are doing everything humanly possible to strengthen the multi-door court. Indeed, there is already a bill we're preparing a bill for submission to the House of Reps that normally sits in legislating for the FCT. We want a court of arbitration, the FCT Court of Arbitration, akin to the Lagos Court of Arbitration. This, we believe, will not only expedite the process of conflict resolution in the FCT, but I think the government of today, tomorrow, and next will find it as an avenue for credibility internationally. Because if multinationals are aware of the fact that in the event of any disputation arising from any disagreement with the federal government, there's a fast-track means of resolving the disputation. Before the end of this year, I'm going to commission a commercial court for the FCT. We have new courts, 4 of them, almost near completion. I will have them taken over by perhaps end of April. We are going to dedicate those courts mainly for commercial cases. That is the time when I will have the Nyanya Karu Judicial Division. I am going to dedicate that division for commercial cases mainly. And judges to be designated will undergo special training in handling those cases. This, we believe, will promote meaningfully a very fertile ground for multinational companies to feel safe that Nigeria is a place for investments.
Okay. Picking from part of the comment you just made, why, my lord, do you think that lawyers would prefer litigation to alternative dispute resolution? Could it be in terms of enforcement? Is there no enforcement in the multi-door courts? Or why would they prefer?
Why should there be difficulty? Why should there be difficulty with implementing what people have voluntarily agreed to? If two people have sat down to say, okay, plus minus, we are agreed, we are resolved, and no more disputation on terms. We have agreed on so. There can't be any problem of implementing the decision. But even then, in some cases, there are referrals to the multi-door from a court. And where there is such a referral, by the time the terms are drawn, they still come back to court, and the court will adopt it as judgment of the court. All right? And then it could be visited by the coercive arm of the law, any failure to comply. So there shouldn't be any problem of implementation. And where the parties do not want to come back to file their terms, they can, I'm sure they will not have difficulties, because secrecy is one of the cardinal principles of ADR. So if they don't want to make their terms public, because once they register it before the court, it becomes a public document. Anybody can come and see. But many people prefer to go to the ADR because they don't want their terms to be made public. So they resolve there and they go and comply with their terms of agreement, and they embrace each other warmly, no more animosity, no more adverse feelings among themselves. So there shouldn't be any problem with that. Lawyers because it's difficult to change old habits.
Finally, my lord, yes, in this segment, there are some, although you are a court that is under the federal government, but you also operate as a state court.
Yeah.
There are some of your colleagues in states that would wish to apply some of the provisions of the Administration of Criminal Justice Act,
yeah,
and their states are yet to domesticate them.
Yeah.
What does that kind of judge do? Is he at liberty to use some of the provisions?
No, unless the state is able to domesticate that. I can tell you, primarily, really, the FCT Act is meant to apply only in federal courts. But even at the formative period, when the bill was being prepared, states were involved. And we insisted at that time the representation from the various states should not be by a person less than a director. And that is why we were able to have, some of the attorney general were there, some of them the DPPs came, some of them the solicitor general were around, and along with them, we went through the formulation of the document, and then at the bill level, and then the advocacy throughout. The idea is to tactfully sensitize the states, so that by the time the act came into being as it is today, it will be easier for the states to adopt. Let me take one provision of the FCT Act. It has outlawed non-legal police prosecutors from prosecuting. You can never find any lay policeman now prosecuting, as it used to be the case in the FCT. Now, that one has its own challenges, meaning the Ministry of Justice of the Federal must engage in having more hands as lawyers in the Ministry of Justice. I know, like in my state, Kaduna, from what I gathered, the bill which is before the State Assembly, adopting and domesticating the act, is with some serious modifications. I had a discussion with the Attorney General, and the view was that they don't have much money to get more lawyers in the ministry. Therefore, they cannot cover the states with the legal minds. So at the peripheral areas, the police non-legal minds will still prosecute. Now you can see, will still prosecute. Now you can see the act is being domesticated with modifications. It's like when you're adopting an international regime, you don't just accept it in totality without sitting down to look at the peculiarities in your own country. Most state parties will gain time to sit down and say adopted with international regime. So the same thing here. We're a federation with peculiarities, name them, they're there, with bewildering nature. So, but the issue of police non-legal is a common thing. Not many, particularly these days with the economic recession. A lot of the Ministry of Justice may not be able to get as many lawyers to cover the entire state. So it is acceptable and understandable that the police non-legal minds will still have to do some bit of prosecution until when they are able to get enough manpower in the Ministry of Justice.
Yes, that's Justice Ishaq Bello, Chief Judge of the FCT High Court, talking on the runnings of the High Court of the FCT and how the Administration of Criminal Justice Act has been implemented in his court. He also talks about how states can benefit from adopting or domesticating, as they say, this Administration of Criminal Justice Act for the general enhancement of justice dispensation in Nigeria. That has been the scale for you today. We shall be looking at other matters as they come up in the judiciary. See you then.